Thanks very much. Well, ladies and gentlemen, now it's my pleasure to introduce Mark Campbell on my far left. Mark's also a member of Greens Lists. He was admitted to practice in April 1986, signed the bar roll on the 26th of May 1988, so he's been a barrister for considerable time. He was accredited as a mediator in November 1995 and nationally accredited as a mediator in June 2008. Mark seems to have come straight to the bar after doing articles at Landner and Rogers, and he has at the bar established a general commercial practice, appearing in all jurisdictions in his areas of current practice. He's an experienced mediator and from 1995 has been accredited by the Vic Bar. He conducts mediations either as counsel or mediator. And I'm sure from what Doug has said, we look forward to what Mark's got to say as to some of the need to get, I think, specialist mediators for franchising disputes.
Thank you, David. I've prepared a paper, and that's largely because despite the experience that I've had at the bar, I've never been able to master the PowerPoint presentation. And that paper deals more particularly with the question of mediating franchise disputes. And I'd just like to begin by saying that the presentation, I'll briefly summarise the Code's current provisions relating to dispute resolution. I'll then discuss some of the more significant amendments relating to mediation of franchise disputes as were recommended in the Wine Review of 2013, which is contained largely in the exposure draft, and then make some miscellaneous observations concerning the actual conduct of mediations generally that I've in recent times have arisen. In relation to the Code of Conduct as it currently operates, of course, disputes between franchisees and franchisors are costly, time-consuming and disruptive to business and emotionally draining for the parties involved. And the current provisions of the Code, contained in Part 4, dealing with dispute resolutions in clauses 24 to 31, were amended following the review of its operation, or the Code's operation, in 2008. The 2008 review observed that many of the issues which lead to franchising disputes and the need to mediation or alternative dispute resolution mechanisms may be mitigated by the introduction of an explicit obligation in the Code for all parties to franchise agreement to act in good faith. Now, in the 2010 amendments, the government didn't accept that recommendation to include an explicit obligation to act in good faith or mediate in good faith, but did amend the Code to insert clause 23 capital A to provide that nothing in the Code limited the obligation imposed by the common law on the parties to a franchising agreement to act with good faith. Instead, what the 2010 amendment did was principally to introduce a provision in clause 29(8), giving more precise definition to the parties' obligations to approach the mediation in a reconciliatory manner by the inclusion of a list of what was described as necessary and desirable behaviours aimed at discouraging behaviour which may impede the effectiveness of the dispute resolution process under the Code. Now, since, of course, all franchise agreements must contain a complaints handling procedure which complies with clauses 29 and 30 as the Code currently is enforced, and the key points of the Code's disputation procedure can be summarised as follows. First of all, in dealing with a complaint, the initial step is to get the parties to resolve it. Secondly, if the parties can't resolve the dispute within 3 weeks of the complaint being made, then it may be mediated, and the parties may use the services of the Office of the Franchising Mediation Advisor, and the mediation advisor may appoint a mediator if the parties are, if asked to do so. Of course, the franchisor and franchisee must attend the mediation and try to resolve their disputes, and importantly, a party will be taken to trying to resolve a dispute if the party approaches the mediation in a reconciliatory manner, which will include those matters which are specifically referred to in clause 29(8)(a) to E of the Code. Now, that includes attending and participating in meetings at reasonable times, at the beginning of the mediation process, making the party's intention clear as to what the party is trying to achieve through the mediation process. Thirdly, observing any obligations relating to confidentiality that apply during or after the mediation process. And these following points are of particular importance: not taking any action during the dispute, including by providing inferior goods, services or support which has the effect of damaging the reputation of the franchise system, and not refusing to take action during the dispute, including not providing goods, services or support if the refusal to act would have the effect of damaging the reputation of the franchise system. So the 2010 amendments to the dispute resolution provisions were significant because they really did try and make some attempt to give some concrete meaning as to the party's obligation to approach mediation in a reconciliatory manner, and as I say, particularly the provisions of clauses 29(8)(d) and E. Now, the Code, as we know, has been the subject of the 2013 review, and there was, not surprisingly, particular attention paid to the party's obligation to approach the mediation in a reconciliatory manner, and some submissions observed that that obligation, certainly there was a great benefit in the obligation to mediate, but in terms of what it meant to act in a reconciliatory manner, that was felt by many of the submissions to be the subject of, well, it was really meaningless and of little practical effect. And a recurring theme in the submissions that were made to the review about the question of dispute resolution and mediations was that, and the review described these behaviours as questionable behaviours, namely that the parties tended to approach, on many occasions, approached the dispute resolution process with a view to literal compliance with the Code's formal procedural requirements, but apparently not in a reconciliatory manner. The review concluded that the way to address that problem was by the introduction of a good faith requirement being incorporated into the Code, and such a requirement and obligation applying to the dispute resolution process. The good faith recommendation contemplated, as recommended, extending the obligation, I've said, to the negotiation of the franchise agreement, the performance of the obligations under the Code, and the resolution of any disputes between the parties, whether or not there was a valid franchise agreement at the time of the dispute. Now, I've replicated on paragraph 24 that the recommendation in respect of good faith was taken up by the government and is reflected in clause 7 of the exposure draft in the terms that are set out there, and principally clause 7.1 provides that there will be an obligation on each party to the franchise agreement to act towards the other party with good faith in respect to any matter arising under the agreement and this Code. And there is some attempt to further define what that obligation to act in good faith might mean in subclause 2, namely that the obligation to act in good faith includes an obligation for a person to act honestly and not arbitrarily, and to cooperate to achieve the purposes of the franchise agreement, and imposes a significant civil penalty in the event that there is a breach of that obligation. That, of course, begs ultimately the question of what is to act in good faith and what does that mean, and I'll come to that in a moment. But in terms of the procedure that the exposure draft adopts for the resolution of disputes between franchisor and franchisee, those procedures, which are set out in clauses 35 to 44 of the draft, are not dissimilar to those which are currently found in the Code. And Clause 35 provides that a franchise agreement must provide for a complaint handling procedure that complies with clauses 38 and 42, and I've set out on paragraph 6 the provisions of clauses 38 and 42, and they are, as I say, not dissimilar to those provisions which currently apply under the Code in terms of setting up a process. Importantly, there is an imposition of a civil penalty of 300 penalty units in the event that, for example, the obligation that the parties must attend mediation. If that is not done, then that may be met by some civil penalty under the proposed amendments to the Code. Now, importantly, if I turn to the question of what does it mean to mediate in good faith? What does that require? Neither the review nor the exposure draft sought to define that obligation, and in fact the review recommended that the obligation to good faith as defined in the unwritten law should be the guiding light. Now, it's been said, as I've observed in paragraph 32, that good faith is often more easily defined and understood in the negative through defining bad faith. Bad faith conduct in a mediation has been defined as using the mediation process primarily to gain some sort of strategic advance in the litigation process, or imposing some sort of hardship rather than to promote understanding and conflict resolution. Now, the difficulty of defining the concept of good faith has meant that many of the decided cases turn out to be of really limited guidance because they've examined the meaning of the term in the context of a threshold disputes as to whether or not the contractual term to mediate in good faith is sufficiently certain to be even enforceable, and rather than in the context of what it means to negotiate actually in good faith during the course of a mediation. Some guidance to the issue has been provided in a decision in the case of Western Australia and Taylor by Member Sumner. It was a matter that arose in the under the National Native Title Tribunal legislation in the course of negotiating native title in Western Australia. And the allegation of one of the parties was that the government was not negotiating in good faith as required under the terms of the legislation. In dealing with that matter, Member Sumner identified 18 criteria which he thought could be usefully used to make an assessment of that, of whether or not there had been negotiations in good faith, and I've set those out in paragraph 34. The thing that immediately strikes you when you read those criteria is that they are all largely procedural requirements. For example, unnecessary delay. Has there been unreasonable delay in initiating communications? Has there been a failure to make contact with one or more other of the parties? Failure to follow up responses and so forth. That, of course, is one way of objectively analysing the question of good faith, but it really fails to come to grips, I think, with the core issue of negotiating in good faith and what that might mean. Now, I've referred to a decision of Justice Einstein in New South Wales of Ayton and Transfield, where His Honour in that case did really try to come to and make some attempt to come to grips with the problem of certainty in relation to what I identify as the core obligation to negotiate in good faith. And I've set out a passage from His Honour's judgment that His Honour's, and I think that the passage that I've set out does capture His Honour's views in summary, but it's a case that's worthwhile reading because His Honour did reach this conclusion after a very extensive review of the case law and the academic literature in this area of what it meant to mediate and negotiate in good faith. The context in which His Honour was looking at the question arose on an application by the defendant to have the proceedings that were brought against it stayed. It was a claim that was brought and framed in misleading or deceptive conduct, and the argument for the defendant on an application, interlocutory application, was that it should be stayed because there had been a failure by the plaintiff to first mediate in accordance with the agreement that was governed the relationship between the parties, which imposed obligations to mediate and in good faith and so forth. At the end of the day, His Honour, after having examined the factual matters and identified the principles, dismissed the application and held that there was a sufficiently identifiable degree of certainty in the obligation to negotiate in good faith. But His Honour's conclusion about this, as I say, where he tries to provide some guidance over and above merely identifying certain procedural requirements as the indicia, he does try to come to grips with the issue, and he says that the certainty issue does require that the court spell out, even in non-exhaustive terms, the perceived essential or core content of an obligation to negotiate or mediate in good faith. He then says that the obligation may be expressed in the following terms. Firstly, to undertake to subject oneself to the process of negotiation or mediation, which must be sufficiently precisely defined in the agreement to be certain and hence enforceable. Not sure that that really takes it much beyond the identification of being satisfying procedural requirements, but he then goes on to say, secondly, to undertake in subjecting oneself to that process to have an open mind in the sense of a willingness to consider such options for the resolution of the dispute as may be propounded by the opposing party or by the mediator, and B, a willingness to give consideration to putting forward options for the resolution of the dispute. He then identifies that subject only to these undertakings, the obligations of a party who contracts to negotiate in good faith do not oblige or require a party to act for or on behalf or in the interests of the other party or to act otherwise than by having regard to self-interest. He then goes on to give some examples of what it might mean to negotiate with a lack of good faith, but identifies in those examples the difficulties, I think highlights the difficulties of proof that attend whether or not there has been negotiating in good faith, because, as His Honour says, and I've replicated these passages at paragraph 37, a party may in fact pretend to be entirely disinterested in considering options for resolution of the dispute propounded by the opposing party, but that doesn't, of course, mean that there isn't an intention or an engagement in the process to negotiate in good faith. So what these passages, I think, do really serve to underline is the difficulties of proof that will be encountered in seeking to penalise or obtain a remedy where there has been a perceived breach of the good faith obligation. Of course, the allegations of bad faith bargaining are problematic because unlike objective failure to comply with procedural requirements, they require the court to form a judgment regarding a party's state of mind. And of course, that inquiry will be in many cases, if not most, directly in conflict with the ethical rules governing privilege and confidentiality of the mediation. I've made a reference to some United States authorities at paragraph 40, where the courts on occasions have been willing to call witnesses and take testimony to define the party's good faith obligation in adopting certain positions, or to examine rather the party's good faith in adopting certain positions, but it's got to be said that even in the United States, most courts have been reluctant to undertake that task. And in Hunt and Woods, a decision of the Californian Supreme Court, that court overturned a policy-based exception to the confidentiality of mediations that allowed disclosure when it was necessary to determine whether a party had acted in bad faith, and the court held that parties could testify only about non-communicative conduct that occurred during the mediation, and all communication otherwise was protected by privilege. Now that goes back to the examples that were given by Justice Einstein in his decision of Ayton, which underlines again the problem that non-communicative behaviour is not necessarily conclusive proof or proof of anything in relation to a failure to act in good faith in the course of negotiations. So clearly there will be considerable difficulties if a party wishes to call in aid either the civil penalty provisions by referring the matter to the ACCC, or indeed seeking some sort of remedy for breach of the good faith obligation that is now part of, or will be part of, the code from the 1st of January. Now, I am informed that whilst the obligation that is currently in the code, namely the obligation to conduct oneself in a reconciliatory manner throughout the dispute process, has not yet or does not find any role to play in the exposure draft. It is a matter that apparently is not going to be left out. It may, in fact, very well find its way back into the exposure draft or the ultimate code, and that may provide some further guidance as to what constitutes the good faith obligation. Now, I'd just like to finish off with some observations of a practical kind as to the conduct of mediations. They have no necessary specific relevance to, or specifically referable to only franchise disputes. But these observations occurred to me while I was preparing the paper because of a couple of experiences that I've had. And the first, in recent times, the first matter is selecting the mediator. Now, this may seem like, as I say, an obvious, if not trivial point to make, but it's worthwhile giving, I think, some serious consideration to matching the mediator's personal style and skills to the, by asking the question, what are the personalities that are likely to attend the mediation. And I was reminded of the significance of the potential importance of this matter when, during the course of a mediation recently, it was a complete disaster because a rather strong-willed mediator came up against a very strong-willed party to the litigation, and it resulted in a walkout. Now, I'm not saying that that's an extreme example, but I think that the selection and careful thought being given to the mediator and the parties that may very well be attending the mediation and their personal style could be really worthwhile. One thing that also has struck me in recent times is that quite properly parties to the mediation and their lawyers give and pay very close attention to identifying the legal causes of action, defences, and identifying the relevant evidence in support of their claim and articulating their formal positions very carefully. But surprisingly, sometimes the question of detailed preparation of settlement options is wanting, and obviously in most mediations, some form of cash settlement is the primary goal, but I think, as Doug mentioned, in franchising disputes and certainly in what might be the new way in which, or the way in which franchising matters are dealt with under the amendments to the code, the scope for dealing more creatively at mediation and in an attempt to settle any dispute between the parties should be given very careful attention. And not infrequently I've had the experience where the first time any option other than some form of cash settlement is explored is at the mediation, at which point in time there are sometimes real practical difficulties which arise. For example, maybe some sort of ongoing business relationship that's contemplated. The question will be asked, well, before I can consider that, my accountant will have to consider the implications. She's away, or I'll have to get in touch with the bank manager. They're not available. Or I need to speak to my wife, partner, or husband, and they aren't here today. And so the momentum for settlement is lost, and negotiations stall, and a golden opportunity is sometimes missed to achieve a very creative settlement. So it's worthwhile just thinking through all kinds of settlement options that may be available prior to the mediation, which then leads me to my final point about the importance, I think, of pre-mediation conferences. I like to have a conference with the parties and their solicitors, just a telephone conference in the week or so leading up to the mediation, at which time I explain the mediation process, ask the parties to consider how they might wish the matter, or how they see the matter resolving, and what options they want to put on the table for achieving that. And I've found that those conferences, which, as I say, can be just done by telephone conference with the solicitor and the clients, have been really worthwhile for priming the parties, and you don't waste time on the actual day of the mediation going through the process, which might take, an hour or so of the formalities of telling people what is the process and doing introductions and so forth. You can move straight on and move into maximising the time available for discussing settlement. Now, I think that that's about all I wish to say, and I think we can now take questions.
Thanks very much, Mark. I think it's rounded things out very nicely. Plenty of food for thought. So would anybody like to start with a question? I might just make a quick comment. Doug raised the subway systems case down at VCAT, which ultimately was decided in the Court of Appeal that VCAT is a court for the purposes of Section 8, I think it is, of the Commercial Arbitration Act, which means that if you've got a binding arbitration agreement, then a party can force the obligation to arbitrate under the Commercial Arbitration Act. And the question then is, what is a court for the purposes of denying access under that section? It was argued in some way that a court didn't include VCAT, and that succeeded at VCAT level and at first instance level. But what determined it in the Court of Appeal was that the Commercial Arbitration Act is based on an international instrument of the United Nations Commission on Trade Law, and the Court of Appeal looked to that body to ascertain what was meant by court. It's meant really simply an institution of the state to decide disputes rather than a Chapter 3 type of court. So I think that was the reasoning process. Now, any questions about, well, perhaps dispute resolution in this area, which I think Mark's opened up some quite interesting problems of interaction between mediation, negotiation, litigation, perhaps arbitration. Yeah.
Yeah, look, I'd be interested in some comments on a couple of tactics I've seen in the past, whether they might fall outside of the good faith provisions or not. And a couple that come to mind, putting forward a settlement beforehand and then refusing to negotiate the terms of it, even to change typos, or or sending in just the lawyers to the mediation and not actually having representatives of the parties there and saying, well, look, these are our representatives, and then often that's just a stonewall. What's your view on those?
Certainly, in terms of representation of the parties at the mediation, that's dealt with quite specifically in let's see, clause 42, which provides that the parties must attend the mediation, and for the purposes of for the purposes of what will constitute attendance of the parties, clause 4 says that a party is taken to attend mediation if the party is represented at the mediation by a person who has the authority to enter an agreement to settle the dispute on behalf of the party. Now, there are very onerous penalty provisions, civil penalty provisions that apply if that is not complied with, up to $51,000, which does demonstrate the degree of importance that the government and that is placed upon that obligation for parties to attend mediation. There's a very clear signal that's sent by that provision. So if, in your example, a party were to send somebody along that really wasn't properly authorised, that would certainly be a matter that would form the basis of an argument that there has been a breach of the good faith obligation that would attract some sort of penalty. And that, of course, lends itself to a rather more objective assessment of the matter than the difficulties associated in attending upon whether or not there's been negotiations in good faith, which presents a whole different range of problems. How do you prove that? Particularly when, as Justice Einstein has given in the examples, being and indeed, I don't know that I mentioned, in fact, I might have skipped over another case which I think is of real interest, that of Justice Badgery Parker in, where are we? Yes, in the State Bank of New South Wales and Freeman, which is referred to in my paper. It's an unreported decision, but you can have a look at that, because in that case Badgery Parker said, in relation to an undertaking of good faith, an undertaking to mediate in good faith no doubt connotes a willingness on the part of the party to consider such options for resolution of the dispute as are propounded by the mediator or the opposing party, but it does not appear to me that an inference of lack of good faith can be drawn from the adoption of a strong position at the outset and a reluctance to move very far in the direction of compromise without more. So, coming to a mediation and saying, well, this is our position, that without more would not necessarily bespeak a breach of the good faith obligation.
I'd like, just before we leave that one, there's an English case called Unilever on bad faith in the context of lifting without prejudice privilege. I haven't got the citation here with me, but what was said in that case was if conscious bad faith in dealing in a mediation or negotiation will lift the without prejudice privilege. So that might be a case that might be worth having a look at. Yeah, just there.
Mark, do you think if a party to a dispute decided to try and get a resolution of the dispute through the media or social media, by, for example, publicising their dispute and maybe bagging the other side and doing all sorts of things that can now be done on social media, do you think that would constitute a breach of the good faith obligation?
Well, that's very interesting, because it might very well breach an obligation which is not currently proposed in the exposure draft to approach it in a reconciliatory manner. Yes, under the existing code, yes, because I think the detailed, the fleshing out of the concept of what will be taken to constitute acting in a reconciliatory manner under clause 29(8) E and D, or D and E, where you are, I think the precise terminology is you're not supposed to not to take any action during the dispute, including providing various services or support which has the effect of damaging the reputation of the franchise system, could very well be breached by disseminating information over social media which has that effect. As to whether or not it constitutes, I do think that acting in a reconciliatory manner may be a subset of the broader obligation to act in good faith, and so in answer to your question, I think yes, indeed, that could be taken as a breach of the obligation.
Can I just add? I think it's a really good and really timely question. Leaving aside that you'd have tort claims for injurious falsehood and probably defo, I think the other thing which is really interesting is that you can have, well, there's an implied duty of good faith now on the basis of the common law, and so you'd have real issues around that. And I guess the other thing is that there's the possibility of an inferential case. So that's where you've got that level of evidence of bad faith, if you like. I think it potentially takes you a little bit further than some of the cases which Mark's discussed. So I'd imagine if you had clients that were so inclined, you'd probably want to test that.
Yeah, thank you very much. Well, I think we've done very well. Mark, Doug, those two excellent papers, and I think they're a great resource for us. Join with you in thanking the speakers in the usual way. Thank you.